Oh. Okay. I'm going to read evidence overview. Where is it? Probably already have this recorded. In brief, the law of evidence is a system of rules and standards governing the admissibility of proof, testimony, writings, objects at the trial of a civil or criminal action. A good rule of thumb is that all relevant evidence is admissible if competent. For example, it does not violate some exclusionary rule. These exclusionary rules serve as a gateway and are meant to ensure that evidence is reliable and authentic. For example, the hearsay rule, the best evidence rule, or to protect certain societal interests outside of the courtroom, for example, testimonial privileges. Part 2 is the evidence relevant? Explain why each item of evidence is relevant. 1. Does it tend to make the existence of any fact of consequence to the determination of the action materiality more or less probable than it would be without the evidence probativeness? Generally, relevant evidence relates to the time, person, or event at issue, but there are exceptions to certain similar occurrences. For example, to prove causation, B. Prior false claims, C. Similar accidents caused by the same condition, D. Rebuting a claim of impossibility, E. Habit. Distinguish habit from character evidence, which is more general and often inadmissible. For example, Charlie never stops at the stop sign at Main and Oak is a habit versus Charlie is a careless driver, which is a character trait. I'd really love to know the definition of reputation. Anyhow, business routine and industrial custom is the last in the list of relevant evidence relating to time, person, or events at issue, but are exceptions for certain similar circumstances. So again, we're just talking about relevance and probativeness. Interestingly, I feel as though we could have used a better definition. I'm recognizing this looks like it wants to be a definition. Does it tend to make the existence of any fact of consequence to the determination of the action more or less probable than it would be without the evidence? So that's the definition that they're going with for relevance. Or evidence. Policy-based relevance. Evidence excluded for social policy reasons. 1, think about the general rule, but rationale behind the rule and its exceptions and limitations. For example, the first of the public policy limitations on evidence is liability insurance. Then there's subsequent remedial measures, settlement offers, and accompanying admissions of fact. Payments or offers to pay medical expenses and withdrawn guilty pleas and accompanying statements are generally inadmissible. So a couple more notes about liability insurance. It's inadmissible to prove negligence or other wrongful action. It's admissible to prove ownership or control, impeachment, or as part of an admission of liability. Subsequent remedial measures, 2 points on that, is it's inadmissible to prove negligence, culpable conduct, or defect, but it's admissible to prove ownership or control, feasibility of the repair or destruction of evidence. Fourth, settlement offers and accompanying admissions of fact. This is inadmissible to prove or disprove validity or amount of disputed claim, or to impeach by prior inconsistent statement or contradiction. The exception is the pre-existing information not protected. Don't remember hearing that before. I also heard the professor saying that there needs to be like a imminent lawsuit or claim because that wasn't, you know, if someone just blurts something out before you even assess, like after an accident, before you even assess if there's harm or damage, it's probably too soon to be referring to that as a settlement offer. But likewise, payments or offers to pay medical expenses, it's inadmissible to prove liability, but note accompanying statements of fact are admissible, unlike rule for settlement negotiations. Discretionary, and then we talked about guilty pleas. Withdrawn guilty pleas and accompanying statements are generally inadmissible. Discretionary relevance, Rule 403 balancing test. The judge has broad discretion to exclude relevant evidence if its probative value is substantially outweighed by unfair prejudice, confusion of issues, misleading the jury, and undue consumption of time. Character evidence, relevance problem. Determines purpose, substantive or impeachment evidence. For character evidence offered to impeach a witness, see a later section, section 7, infra, which methods are permitted. And you have reputation testimony. And rather than a definition, it just gives an example that Mary has a good reputation for honesty in our community. Reason why I want a definition for this is because I would find it very hard on direct or cross examination to get a witness to say that exact words and then not actually have them back it up with any specific acts, specific prior acts. So, specific acts is the next button. Oh, I'm sorry. Opinion testimony. I think Mary is a very honest person. So that's what the R and O stands for. O is opinion. Specific acts not usually permitted unless the character is directly at issue in the case, which is rare. Or the other option is in a sexual assault or child molestation case, or when the act is independently relevant, for example, relevant to an issue other than the defendant's character, such as mimic. You have motive, intent, mistake, or the absence of the mistake, identity, common plan, or scheme. What type of case is it? Criminal cases. Determine who can initiate and under what circumstances. Defendant may introduce evidence of his own good character to show innocence. When prosecution may introduce defendant's bad character. A, as a rebuttal when defendant opens the door. B, specific acts that are independently relevant. C, specific acts by the defendant in sexual assault or child molestation case is admissible for any relevant purpose, including propensity. And the character of the victim may, let's just, okay, in criminal cases, the defendant may introduce character evidence about the victim if relevant to his innocence, generally in self-defense cases, or B, prosecution may rebut with the defendant's bad character for the same trait or victim's good character for the same trait. In civil cases, character evidence generally is not admitted. The exception is when the character is directly in issue, defamation, for example, negligent hiring, or also another exception is similar specific acts in a sexual assault or child molestation case, or specific acts that are independently relevant in mimic. So that would be your civil cases. And I think this is where the rape shield statutes sit. Real evidence, part 3 is the next thing that we're going through. One, object is presented directly to the trier of fact for inspection. Two, allows the trier of fact to reach conclusions based upon his own perceptions rather than relying upon those of witnesses. B, types and examples, direct, offered to prove the facts about the object as an end in itself. Example, evidence of a permanent injury can be shown by the injury itself. Circumstantial facts about the object are proved as a basis for an inference that other facts are true. For example, in a paternity case, the child can be shown to the jury to demonstrate that the child is of the same race as the alleged father. Um, Original has some connection with the transaction that is in question at the trial. For example, what is original real evidence is the alleged murder weapon in a murder case. Prepared real evidence, also called demonstrative evidence. These are like new words I'm not recognizing as being used before. So we're talking about demonstrative evidence. Examples are sketches, models, jury view of the scene. And part C, real evidence must be authenticated, which means recognition testimony by witness if the item has recognizable features. And chain of custody is the second point under authentication. If evidence of the type is a type likely to be confused, or if it can be easily tampered with, A, proponent must show that the object had been held in a substantially unbroken chain of possession, and B, need not negate all possibilities of substitution or tampering, but must show adherence to some system of identification and custody. And if you don't, the reason I ask that is because it says need, not negate all possibilities of substitution or tampering. Um, it doesn't need to do anything. I'm pretty sure it depends on what side you're on. Nobody needs to do anything. Um, if chain of custody is an issue, you don't need to meet any requirement to bring that evidence to court, like meaning questioning the witnesses about it. And it's not like if you didn't negate all possibilities, like it was somehow barred, like the exclusionary rule would apply. Like that's doesn't really make sense. I don't like saying the word need in that sentence. Part 4, documentary evidence, common issues. A, has been authenticated. Writings must be authenticated by proof showing they are what the proponent claims they are, unless self-authenticating, such as newspapers, commercial paper, etc. By commercial paper, I'm wondering if we're talking about like a label on a product. Standard for authentication, proof sufficient to support a jury finding of genuineness. So that's the standard of authentication. So let's say you didn't meet that. So like, now I'm starting to challenge all this. Let's just say you didn't have sufficient proof of genuineness. Does that mean that your documentary evidence is inadmissible? Curious. Probably. Authenticated by stipulation between obviously like the defense and prosecution parties. Evidence of authenticity, for example, etc. And oral statements only when important. I don't know if evidence of authenticity has to do with like attestations. It's as broad as could possibly be. Coming after authenticated by stipulation. Oral statements only when important. What are we talking about here? Has it been authenticated? Oral statements? in documentary evidence. So so this part 4 is documentary evidence, common issues. Part A is a question, has it been authenticated? And it's saying writings must be authenticated, of course, authentication by stipulation, and then it just says oral statements dash only when important. So I'm not sure what they mean by that. Like at a certain point when your outline is so chapped up that it doesn't even make sense, is what I'm reading right now. That's evidence rule, original document rule. In proving the terms of a document, including a recording, photograph, or x-ray, where the terms are material, the original writing must be produced. Secondary evidence is allowed only if the original is unavailable for some reason other than the serious misconduct of the proponent. Two, rule applies only in certain situations. When the writing is a legally operative or dispositive instrument, for example, contract, deed, will, divorce decree, and when the witness's knowledge of a fact comes from having read in the document, if the fact exists independently of a writing, the best evidence rule does not apply. I'm surprised that it's not saying like for the content of the document. It doesn't say that anywhere here. But I think that's what the best evidence rule applies to. When the content of the document is at issue, not just the fact that the document exists. So what it says here is when the witness's knowledge of a fact comes from having read it in the document, if the fact exists independently of a writing, the best evidence rule does not apply. This is like just more mysterious. Part 5 is the witness competent to testify. A, requirements for all witnesses. Federal rules say 1, 2, and 3. Personal knowledge of the subject matter, sworn oath or affidavit that witness will testify truthfully. And third, all witnesses presumed competent under the federal rules until the contrary is demonstrated. And in parentheses, it says no age requirement. And then does the Dead Man Act apply? Not recognized by the federal rules, but the statutes vary by state. May bar an interested, the Dead Man Act may bar an interested person from testifying in a civil case as to the communication with the deceased if such testimony is offered against the representative of the deceased, for example, the executor, and many exceptions to act and door openers. So it can bar an interested person like interested in the outcome of the case, from testifying in a civil case as to their communications with the deceased person, if such a testimony is offered against the representative of the deceased, which is often the executor. So is opinion testimony appropriate? Lay opinion testimony requirements. Rationally based on the writing's perception, helpful to the jury, and not based on scientific or technical knowledge. Common examples is general appearance or condition of a person, state of emotion, speed of moving object, intoxication, sanity, and voice or handwriting identification. I feel like there should be an mnemonic for that, but it's not in an order that I recognize. A mnemonic. Expert opinion testimony is the subject matter one where expert testimony would assist the trier of fact, and then in parentheses it says relevant and reliable. Under that, the court acts as a gatekeeper to determine reliability, and there's the Daubert test is referred to along with that statement. Is the expert qualified on this subject? Is the second question. Does the expert possess reasonable probability regarding her opinion? It can't be speculation, is what I heard the professor say. Is the opinion supported by a proper factual basis? Personal observation, facts made known to her at trial, or facts supplied outside courtroom, and of a type reasonably relied upon by experts in the field. 7, can the credibility of the witness be impeached? A party may attack the credibility of any witness, even its own. Common methods: impeachment by cross-examination, and some methods, extrinsic evidence. 1, 2, and 3, prior inconsistent statements, bias, and prior conviction of crime is written here. Any crime, misdemeanor, or felony involving dishonesty or false statement. And it says here that the judge would have no discretion to exclude prior convictions of a crime, of a misdemeanor or felony which involved dishonesty or false statement. Any other felony, limitation on remoteness, it's generally accepted that it's a 10-year rule, is what qualifies the word remote. Prior bad acts must be probative of truthfulness, for example, an act of deceit, and cross-examination only, no extrinsic evidence, is what is said within the prior bad acts section. Right. Opinion or reputation evidence of truthfulness. So you could say, like, did you get arrested last week for check kiting? And that's on cross-examination, yes or no. If they say no, then you may not present any extrinsic evidence of that arrest. And I say arrest specifically because generally arrests are not even technically prior bad acts until there's more proceedings. My eyes are bothering me. Opinion or reputation evidence of untruthfulness is another way to impeach a witness. Sensory deficiencies, such as inability to hear or see. Contradictory facts. I guess I saw maybe the Abraham Lincoln case where, oh no, I don't remember. Something's like, was there a full moon when the crime occurred, such that it could be viewed, like seen outdoor? And like, I think farmers, he used like Farmer's Almanac to show that there wasn't a full moon, so that contradicted one of the basic premises that like case was hinging on. Part 8 is the testimony privileged. General approach: identify the privilege, its scope, and its holder. Are there any exceptions, waivers, or limitations? Applicability in federal court. This is a general approach for privileges: identifying the privilege's scope and its holder, if there's any exceptions, waivers, or limitations. And in federal courts are recognizing the attorney-client privilege, spousal immunity, marital communication privilege, psychotherapist, social worker client privilege, clergy penitent privilege, and governmental privileges. What are governmental privileges? Oh, like what you say on in Congress. If not one of those, does state law apply with respect to privileges? For example, is it a diversity case? Now, for privileges, attorney-client is listed first. The client must be seeking the attorney's services at the time of the communications. The communication must be confidential, not intended to be disclosed to third parties. The termination of an attorney-client relationship does not terminate the privilege, even if it survives death. It even survives death. Special rules for corporate clients as to who is the holder of the privilege. Non-applicability, where the client seeks legal advice in aid of crime or fault. Parties claiming through the same deceased client. Dispute between attorney and client, for example, malpractice. Client puts legal services at issue. Physician. Okay, so that's when they don't apply. So those 4 examples are when they don't apply. When the client puts a legal services at issue in like a dispute between the attorney and the client, such as malpractice. Then the parties are claiming through the same deceased client, or when the client seeks legal advice in aid of crime or fraud. Also doesn't apply if it's no longer confidential, because that person like emailed the attorney's opinion to people who didn't need to see it. Physical patient. Physician-patient. No federal privilege, but recognized in many states. Information must be acquired while professional relationship exists. While attending patient, and information must be necessary for treatment. Non-applicability, dispute between physician and patient, for example, malpractice, and patient puts a physical condition at the issue, which is an example of this is in a personal injury lawsuit. Psychotherapist, social worker client, similar in operation to the attorney-client privilege. And then privileges related to spouse. For spousal immunity, the privilege not to testify in a criminal case only applies to criminal cases, and the privilege belongs to the witness spouse under the federal rules and can only be asserted during marriage, although the matters at issue may have occurred prior to marriage. And for the confidential marital communications privilege, which protects communications during marriage, not observations, and it applies both in civil and criminal cases, and the privilege belongs to both spouses. So the communication must have been made during a valid marriage, but divorce will not terminate the privilege retroactively. Exceptions is that neither privilege applies in legal actions between the spouses, cases involving crimes against the testifying spouse or either spouse's children, and in furtherance of joint crime or fraud. Other privileges: clergy penitent, accountant client, professional journalist, governmental privileges again, and it's funny, they just list them out again. I think, yeah, there's nothing new there. Part 9 is a statement barred by the hearsay rule. Was there an out-of-court statement, example, oral or written assertion, or nonverbal conduct intended as an assertion? Note that non-human or animal or machine declarations are not hearsay. Is it being offered for the truth or some other purpose? So that's a definition of hearsay, is an out-of-court statement being offered for the truth of the matter asserted. If offered for its truth, it is hearsay. If not offered for its truth, it is not hearsay, such as legally operative facts, example, words of contract or defamation, offered to prove effect on the reader or listener, circumstantial evidence of the declarant's state of mind, and impeachment are all offered for something other than its truth. Hearsay within hearsay is both to be admissible, both the inner and the outer statements must fall within a hearsay exception. If a statement falls under the hearsay definition, is it nonetheless categorized as non-hearsay under the federal rules? There's 4 examples. One is statement by an opposing party, also called admission of a party opponent. And A, B, and C. A statement by or attributable to a party offered against that party need not be against interest. Adoptive statements, for example, party silence in the face of an accusation, and vicarious statements, for example, made by the party's authorized spokesperson, agent, or co-conspirator. Prior inconsistent statement of testifying witness when made under oath at a prior proceeding or deposition. Prior consistent statement of testifying witness in certain circumstances when offered to rehabilitate an impeached witness, and prior statement of identification of testifying witness, for example, photo identifications. Part C, if the statement is hearsay, does it fall within the hearsay exception? And the unavailability exceptions include former testimony if it's under oath and the party against whom the testimony is offered or his predecessor in interest in civil cases must have been a party in the former action. And if I recall correctly, there's more to it than just that. They needed to have to be about the same issue, and they need to be give the party against whom the testimony is offered the opportunity to confront or like cross-examine that testimony in this earlier proceeding. Statement against interest. The declarant must have known that the statement was against her pecuniary, proprietary, or penal interest when it was made. Dying declarations, belief that death is imminent concerning the cause of or circumstances of death. This applies only in homicide in civil cases, and the declarant need not have actually died, which is important because some of these questions I'm seeing lately are like they're in a coma and they have been for a while. The next item is statement of personal or family history. Declarant must be a member of the family in question or intimately associated with the family. And then the statement against party procuring unavailability. The unavailable declarant's hearsay statements are admissible against the party who procured her unavailability by deliberate wrongdoing. Now, common exceptions where the declarant's unavailability is immaterial is excited utterance, which are hearsay statements made under the stress of an exciting event, the present sense impression, which is a statement that must be made during or immediately after the event or the condition. The third, the then existing state of mind, emotion, or sensation, which is a state of mind that's directly at issue in a case, which I find it interesting. The example they're using is domicile. Maybe they don't mean domicile. And secondarily, under the state of mind, emotion, or sensation, then existing is to prove subsequent acts of the declarant. And for the last type in this section called common exceptions to where the declarant's unavailability is immaterial, you say exceptions relating to bodily conditions. A statement of own present condition is admissible even if not made to a physician. And if a statement made for medical diagnosis or treatment includes past conditions and includes a cause or source of injury if pertinent to diagnosis or treatment. Business records. A record must be made in regular course of business, and matters must be within the personal knowledge of the entrant or someone with a business duty to transmit such matters to the entrant. And I think another important element here is that they need to be like authenticated by someone familiar with these records. Recorded recollection is a document not admissible but may be read to a jury. And various foundational requirements must be met. The witness must not be able to remember the facts, must have been the writing must have been made or adopted by a witness when the events were fresh in their minds. and distinguish refreshing collection in which the witness testifies from their own memory after reviewing the document as not a hearsay problem. I'm a bit surprised that they don't go into refreshing recollection refreshed. In wait, this one's recorded recollection. Document not admissible, but may be read to the jury. I'm gonna kind of look at that. Those two types again. Recorded recollection and recollection refreshed. Official records. Which is like those at the county recorder of deeds, or the registry of wills. Ancient documents are statements and authenticated documents prepared before 1998. Learned treatises, if used during examination of expert and established as reliable. Statements and documents affecting an interest in property, and catch-all exception if not covered by a specific exception, but guarantees of trustworthiness can be demonstrated, and the statement is strictly necessary. And lastly, the notice has been given to the adversary. So, like, maybe there's just no other way to demonstrate, like, an essential, which makes it a shame because, like, in a criminal case, for instance, there's, like, one essential piece of evidence and it happens to be hearsay, like, you can get a catch-all exception. But I feel like that should only take place in civil if it's that central to the case. Like, criminal cases really shouldn't be decided on hearsay and only hearsay. Are there any confrontation clause issues? Criminal cases only. 1, 2, and 3. A hearsay statement offered against the accused in a criminal case is barred by the confrontation clause, even if it falls within a hearsay exception. If the declarant is unavailable, the statement was testimonial in nature, and the accused had no opportunity to cross-examine the testimonial statement prior to trial. What is a testimonial statement? Statements made in the course of police investigation when the primary purpose is to establish facts potentially relevant to a later criminal prosecution. Statements made to assist police in an ongoing emergency are non-testimonial. Affidavits or written reports of forensic analysis are also testimonial. Confrontation clause rights may be forfeited if the defendant commits a wrongful act intended to keep the witness from testifying at trial. And then criminal defendants have the right against self-incrimination. So just going to put that out there. So I'm going to mark this as completed. There was a suggestion as to going to look at the CMR because there are some new materials, but I actually only see California materials. So I'm not sure if I find... No, because it's California. I mean, I guess that's fine. It'll tell me if it's California evidence. But the thing is, it was recommended that I look at like some table which compares federal to California evidence. So I'm gonna go to the table of contents and see if I can't find what it is that BARBRI recommended we looked at. More information page for updates to evidence, California evidence distinctions chart supplement to be printed, evidence CMR supplement to the California evidence CMR. Evidence distinctions, California. How do I get to it? I'm not actually seeing it. I see it on the table of contents, like page 1 of the table of contents. But when I go to the contents that I can navigate to on like the left bar, I don't see anything about California distinctions. And when I go to the table of contents for evidence, I don't see it like at the end of the table of contents either. Let's try one more time. Oh, here's California evidence distinctions. It's its own section. So how long is this? This is a long table of contents. It's got just as much material in it as does federal rules of evidence. But I'm just going to navigate. Okay, there's a lot of hypotheticals. I'm going to navigate to the end and see if there's a table in here of distinctions, because it was the table that they recommend that we look at. All right. These are not that painful to read. I don't see a table.